ought to be caught and put behind bars. But the problem is that these methods of calculated deception are too effective. They do not merely work on the guilty. At least some of these methods, it turns out, have proven to be just as effective in getting innocent people to make incriminating statements, and sometimes even outright confessions. Do not think for a minute that you can trust a police officer who seems to be open-minded and undecided about whether he will arrest you after you are finished with an interview. The police are trained to act that way, to get you to talk with them for many hours until you finally give up in exhaustion. The most recent and comprehensive investigation, which took a careful look at 250 prisoners exonerated by DNA evidence, found that 16% of them made what's called a false confession, admitting their commission of a crime that they did not commit. Those are the cases in which the defendant actually confessed. In many more cases, the innocent suspect denied all guilt, sometimes for hours, but still gave the police a statement that was then used to help convict him. Out of all the hundreds of innocent men and women who were wrongly convicted but later exonerated by DNA evidence, more than 25% made either a false confession or an incriminating statement. Every one of those suspects would have been much better off and might have avoided going to prison altogether if they had simply read this book. Many years ago, when the world was much simpler than it is today, a young legal advisor named Jiminy Cricket was able to cheerfully and enthusiastically advise Pinocchio, "Always let your conscience be your guide." It was not terrible advice at the time, because in those days there was a fairly close correspondence between law and morality. In those days, nothing was forbidden by the law unless it was obviously immoral, dishonest, or dangerous to the general public. It was almost inconceivable that an accused criminal could ever claim to have no idea that whatever he or she was doing was against the law. Those days are long gone. Because of the matrix of rampant horrors often described as over-criminalization, it is no longer possible for you to rely on your own conscience or common sense as a reliable guide for whether you have committed a crime. One recent investigation revealed that the United States Congress was passing a new criminal law once a week on average. It has been reported that the problem is so severe that even the Congressional Research Service is no longer able to keep count of the exact number of federal crimes. These laws are scattered throughout all the sections of the United States Code and include thousands of criminal statutes. Even if you somehow had the time to read every page of the federal laws written down in the United States Code, and even practicing lawyers no longer have the time to read all those laws, you still would not know all the different ways you could be prosecuted by the federal government. That's because many of those statutes written by Congress reference the obscure provisions of many thousands of regulations that have been issued by every federal regulatory agency. It has been estimated that there are tens of thousands of these obscure regulations, any one of which could potentially subject you to criminal prosecution. And that is just the list of federal criminal statutes. The states have an even greater number of crimes on the books. As Justice Stephen Breyer of the United States Supreme Court correctly complained in 1998, the complexity of modern federal criminal law, codified in several thousand sections of the United States Code, and the virtually infinite variety of factual circumstances that might trigger an investigation into a possible violation of the law, make it difficult for anyone to know in advance just when a particular set of statements might later appear to a prosecutor to be relevant to some such investigation. In other words, the deck is stacked heavily against you and you have no idea what you are up against. People who want to read all the federal laws on the books, if they had 3 decades of free time on their hands, could find them all at any law library collected in a voluminous set of books called the United States Code, which is organized in different sections called titles. One of those 52 sections, known as Title 18, is called Crimes and Criminal Procedure. It is where any ordinary American citizen would expect to find a complete list of all the crimes recognized under federal law. But even if you took years of your life to read through that entire portion of the code, believe it or not, you would have missed hundreds of the criminal laws on the books because they are not all contained in Title 18. Why not? There is not one good reason. It is almost as if our government was determined to do whatever it could to make it nearly impossible for the average American to have any idea what is and what is not forbidden by the law. Legend has it that one wicked Roman emperor had his laws posted on the top of a high pillar so that